Hello, everyone. Welcome to the third Asia Pacific Forum of The Hague, co-hosted by the International Criminal Court and Hague Project Peace and Justice. We are very happy to host this event today, 17th July, which is the International Justice Day. I'm Yumi Omiya from the Eicc, and I'll be the host of this event. Before we begin, a couple of housekeeping rules. We have 2 panel discussions with Q&A, and the whole event will be recorded. It will be uploaded on Eicc official YouTube channel, and the event will be in English and no interpretation is available. Let's kick off the session, and first we have the welcome remarks. Unfortunately, the president of the Eicc, His Excellency Judge Piotr Hofmański, is unable to be with us today, but I have the honor to share with you his recorded welcome remarks. So let's watch the video first.
Ladies and gentlemen, it's a great pleasure for me to welcome you all to the third Asia Pacific Forum on the International Criminal Courts. I would like to thank Mr. Nora Stehover and the Hague Project Peace and Justice for co-hosting this event with the Eicc. The Asia Pacific Forum started in 2018 with the goal to facilitate an open dialogue about the Asia Pacific region's engagement in the Eicc system. This forum also encourages young professionals to consider a career in international criminal justice and more specifically at the Eicc, where we hope to attract more staff from the Asia Pacific group of states. Let me state at the outset that the contribution of the Asia Pacific region to international criminal justice has been very significant. Some of the significant institutional predecessors of the Eicc were located in the Asia Pacific. This includes notably the International Military Tribunal for the Far East, which was set up in the aftermath of the horrors of the Second World War. More recent examples are the extraordinary chambers in the courts of Cambodia, the special panels of the Dili District Court in East Timor, and the Special Tribunal for Lebanon, which all form an important part of the development of international criminal justice in the last 3 decades. Countries of the Asia-Pacific group of states also took active part in the negotiations on the Rome Statute and made important contribution to the drafting process. And although the Asia-Pacific is the most unprecedented region in the Eicc system, it has produced many top officials of our court as well as other international and hybrid tribunals. In the Eicc, we have had judges from Japan, the Republic of Korea, the Philippines, and Samoa. Among them, Judge Sang Hyun Song served for 6 years as president of the court. As for other top officials, Zaid Al Hussein of Jordan was the first president of the Eicc's Assembly of State Parties, and more recently, International Judge Ongon Kwon served in the same role. Mr. Moto Noguchi served 2 terms as the chair of the board of directors of the Trust Fund for Victims. Currently, the Asian judges serving to the Eicc are my dear colleagues Judge Chang Ho Chung and Judge Tomoko Akane, and I am delighted that they will address you in the first panel today, introducing the work of the Eicc from their respective viewpoints. In the second panel today, you will have the opportunity to hear some of our staff members from the Asia-Pacific region who will share their careers stories at the Eicc. I hope this panel discussion will inspire you to consider applying for a job or an internship at the Eicc. Despite the important contributions of the Asia-Pacific, we do not have enough staff members from the region and the court, and we would really like to see that situation change in the future. We also hope that the more people from the Asia-Pacific region come to work with us, the more, and it will help spread understanding of the Eicc and over time contribute to interest in joining the Rome Statute among those states that have not yet done so. The legal protection of the Rome Statute against atrocity crimes belongs to all of humanity. I very much hope to see more countries from the Asia-Pacific to strengthen the system. Ladies and gentlemen, once again, I'd like to welcome you to this important forum today. I hope you will find today's discussion interesting and that they will help to deepen your understanding of the Eicc and give you ideas for your future careers. Thank you for your attention.
I thank Mr. President for his remarks. Now, it is my great honor and privilege to invite the permanent representative of the Netherlands to the OPCW and Eicc, His Excellency Ambassador Paul van den IJssel, to deliver the keynote speech. Ambassador, thank you for being with us today. The floor is yours.
Thank you very much. I hope you can hear me, otherwise let me know. Excellencies, judges, and dear participants, it is indeed a pleasure and an honor as representative of the host state, the Netherlands, to have the opportunity to speak to you. I very much regret that this discussion, due to well-known circumstances, has to take place in a virtual mode. A mode that does not allow you to see with your own eyes the beauty of the premises of the Eicc here at the edge of the dunes close to the sea. As a Dutchman, I can truly say that the building of the court is an asset to The Hague, a precious asset, just like the Eicc itself, which we are very proud to host. A precious asset for a city that is seen worldwide as the city of peace and justice. A precious asset for a country that has the promotion of the international rule of law enshrined in its constitution. A country that sees accountability and the fight against impunity of international crimes as core elements of its foreign policy. More importantly, however, the Eicc and the system it stands for is an asset to the world. A world in which the respect for the rule of law should be the dominant factor between states and their citizens, and between people. This in contrast with a world where might is right. We have learned many bloody lessons in our history about where that leads us. And we are still learning. Yes, and there are still many states and persons who have doubts about the value of the rule of law, especially when things get critical or close. Only 123 states today are party to the Rome Statute, the founding treaty of the International Criminal Court. So there's a lot more convincing to do. Many of these states will probably agree with us about the need to fight impunity, but for many different reasons, they shy away from joining those who have signed up to the treaty. Together with the Republic of Korea, the Netherlands is in the lead of trying to convince more states of the importance of ratifying the statute. In this fight against impunity for international crimes, the Eicc is not the only player, not the only instrument. We have regionally limited courts, we have national courts, we have non-judicial entities like the IIIM and the Commission of Inquiry of the Human Rights Commission. They also play a role. Not to mention the role of many civil society organizations on the ground. Nevertheless, I think it's a fair conclusion that the Eicc is the most known, the most visible expression of our ambition to establish accountability for the perpetrators of the most horrible crimes. Therefore, the Eicc deserves all our support. Therefore, we have to do whatever we can to let the Eicc do its job in the best possible way. In that respect, it is sad to see that the Eicc has become in recent years the subject of accusations, political attacks, and only recently of sanctions. Fortunately, these sanctions have been lifted, but it remains important that the states parties and all those who believe in accountability stand firm in defense of the court. That is not to say that we should be blind for things where the court should do better. Exactly because we think the court and the Rome system are precious assets, we have to maintain them and at times adapt them to changing circumstances. Therefore, the states parties and the court started a comprehensive review of the functioning of the court. A panel of eminent international experts looked at the functioning of the court and of the system and came up with 384 recommendations to strengthen the court. At present, the states parties and the court are studying these recommendations with a view to their implementation. The Netherlands and I personally are very happy and proud that the Netherlands, together with Sierra Leone, plays a leading role in this process. Dear participants, during this forum, there will be other people who will speak in much more detail and with much more knowledge about the functioning of the court. But as a diplomat and representative of my country, I can say that the court plays a key role in the global fight against impunity and thereby is also preventing these crimes from happening. In doing that, the court really makes an enormous difference in the life of ordinary people. Sometimes the difference between life and death, sometimes a difference between hope and despair. To me, that seems to be a fantastic place to work and a fantastic objective to contribute to. As to the Netherlands and The Hague, I can just say you are more than welcome to the City of Peace and Justice and to the Netherlands and become part of that vibrant community that is working for the promotion of the international rule of law and hence a better world. I wish you all a very fruitful discussion today. Thank you very much.
Thank you very much, Ambassador, for your inspiring keynote speech. That brings us to the first panel discussion of the day, the high-level dialogue with the Eicc judges. And I have the honor to invite the moderator of the first panel, Her Excellency Ambassador Nora Stehauer, the former ambassador of the Netherlands to the international organizations in the Netherlands and currently representing Hague Project Peace and Justice. Ambassador, thank you for being with us today, and the floor is yours.
Thank you, Yumi. Good morning, excellencies, ladies and gentlemen. I say good morning, but I should say also good afternoon, good evening to you all. Great that so many students, young professionals, and other interested persons in various countries from the Asia-Pacific region and from the Netherlands have logged into this forum. Today, coinciding with International Criminal Day, and for the third time, we pay special attention to the Asia-Pacific region in order to explore greater engagement of the region to the system of the Rome Statute. I thank Judge Chung for the initiative which he took 3 years ago and which he continues to promote. I am, as you have heard, a former Dutch diplomat and a lawyer with great interest in the Eicc, and I'm very happy to cooperate with the Eicc on this important event. We will first show a little film on the Eicc in order to refresh your mind on its functioning. Then there will be a discussion with Judge Akane and Judge Chung, after which we will go into the Q&A session. You can ask your questions in the Q&A box, which you see at the bottom of your screen. I would like to point out in advance that this panel session is focusing on the functioning of the court and how it works. So please do not submit questions on political matters or pending policy issues of the court. That goes beyond the scope of this session and will not be answered. Let us show now the 3-minute film on the ICC.
How can a victim of mass crimes have recourse to justice? And how can we prevent atrocious crimes now and in the future? The world is taking action against atrocious crimes with support of the international community, including civil society groups. Countries worldwide created an international treaty in 1998. The countries ratifying the treaty started to grow, and it took effect in 2002, officially establishing the International Criminal Court, or ICC. The court is unique in that it was created by a treaty and not by the United Nations, which it cooperates with but remains independent from. The ICC tries individuals, not countries or organizations, for 4 crimes: genocide, war crimes, crimes against humanity, and, once the 2010 amendments to the Rome Statute take effect, the crime of aggression. Since the ICC was established in July 2002 and does not have retroactive jurisdiction, the ICC cannot address crimes committed before July 2002. The ICC has jurisdiction in these locations. First, on the territory of states parties or countries that have accepted the ICC's jurisdiction. Second, in other countries if the crimes are committed by nationals of states parties or countries that have accepted the court's jurisdiction. Third, in other countries if the crimes were referred to the ICC prosecutor by the United Nations Security Council pursuant to a resolution adopted under Chapter 7 of the UN Charter. The ICC does not try every case in these locations. Countries have the primary responsibility to do so. The ICC does not replace national courts but complements them. As a court of last resort, it only prosecutes cases when a country is unwilling or unable to do so genuinely. The ICC conducts work both in the courtroom and in the field and relies on cooperation with countries in order to fulfill its mandate, particularly for making arrests, transferring arrested persons to the ICC detention center in The Hague, freezing suspects' assets, and enforcing sentences. The Rome Statute created 3 bodies: the Court, the Trust Fund for Victims, and the Assembly of States Parties, which provides oversight management. The ICC has 4 organs. First, the Presidency, then the Judicial Divisions, with 18 judges divided in 3 divisions: pretrial, trial, and appeals. Third, the Office of the Prosecutor, which is an independent organ of the court and which conducts investigations and brings cases before the court. And finally, the 4th organ is the ICC's registry, which provides support so the court's work runs smoothly. The ICC exists to hold people accountable if they commit atrocious crimes, thus helping to prevent such crimes from happening again.
Thank you. Thank you for this interesting film. And I would now like to introduce the judges from the court, Judge Akane and Judge Chung, who are here today to share their views with you. I thank them for their willingness to do so. Her Excellency Judge Akane joined the ICC in 2018. Prior to joining the ICC, Judge Akane served as Japanese ambassador for the International Judicial Cooperation. Before, she served inter alia as a public prosecutor in Japan. Judge Akane also acquired experience in academia as professor of criminal justice practice at several universities in Japan. Judge Akane will focus her introduction on her work as a judge in the pre-trial division of the ICC and the trial case she is involved in, and she will highlight the transition working for a domestic court to working within the ICC system. His Excellency Judge Chung from the Republic of Korea was elected as an ICC judge in 2015 for a term of 9 years. Prior to the ICC, Judge Chung served as a UN judge in the extraordinary chambers in the courts of Cambodia in Phnom Penh. Before that, Judge Chung served in several positions as a judge in the Republic of Korea. Judge Chung will go into the question of reparation for the victims. As you know, victims are an essential part of the ICC system. When the ICC was set up in 1998, the states parties introduced a unique role for the victims, which was new in international criminal law. Judge Chung will explain what is behind the concept of reparation and the process of integrating that concept in the judicial procedures. But let me first give the floor to Judge Akane. Judge Akane, please, you have the floor.
Thank you, Madam Chair, for your kind introduction. My name is Tomoko Akane, one of the ICC judges of the pretrial division. So my main responsibilities cover the situations and cases which are assigned to my pretrial chamber. But I'm also in charge of a trial case assigned by the presidency. In sum, I am now involved in some situations and cases which are in the pretrial stage and a case which is in the trial stage. Due to the time constraint, I will not delve into the matter today, but the function of the role of the pretrial chamber is unique to the ICC. One of its important functions is to confirm the charges and to decide whether the cases go to the trial. Unlike Judge Chung, I have no experiences in any other international courts before. During my transitional era, some Japanese from a Japanese criminal justice system to the ICCs, I found some major differences between the domestic and the ICC system with regard to the nature of the cases and the ways to deal with. The first and biggest difference I found is the scale and the magnitude of the cases, as you may easily imagine. Although, even in the domestic field, there are also important cases in terms of the gravity, complexity, and the number of the persons involved or affected. It might be a rare case which involves entire country and affects vast majority of the population of the country. On the contrary, with regard to the ICC cases, the magnitude of the case, including the scale and the atrocity level, could be outrageous. As you may know, the material jurisdiction of the ICC is limited to 4 categories of the most serious crimes to the international community, such as war crime and crimes against humanity. The numbers of the affected people could reach millions. Moreover, I, who is used to see the distressing images of the crime scenes, am sometimes overwhelmed by the atrocities having been committed in those countries. Consequently, investigation and prosecution of such crimes is extremely difficult. Such a huge scale of crime generally leads to a large number of victims and witnesses who are subject to the investigation and court proceedings. In many cases, with some exceptions, such countries are in the middle of the armed conflicts or still in a transitional stage to the peace process. And many affected people have been displaced from their original hometowns to other regions or even to foreign countries. And as you know, almost all the witnesses and other evidence exist outside the Netherlands, where the ICC is located. You may easily imagine that it is extremely difficult to access to the evidence or affected people and to find out the most responsible persons of such crimes. Moreover, many of the evidence have been lost during the times of the armed conflict or during the state of emergency when such crimes were committed. Many of the evidence which could be gathered may be indirect or hearsay in nature. Having such individual evidence is insufficient to prove an incident, let alone to show the entire criminality. Consequently, large number of corroborative evidence is sought to prove the case. Thus, usually, the number of evidence for the judicial proceedings amounts to tens of thousands. Although the number of the witnesses who are actually called up to testify is limited for the sake of expeditiousness and effectiveness of the individual of the judicial proceeding, and in accordance with the principle of the best evidence. Nevertheless, usually nearly 100 or more witnesses testify in court. It is really a time and energy consuming process to establish the truth. Second, I found that is maybe partly related to the first one, but the protection of the witnesses is a very crucial matter for the ICC cases. Of course, in the domestic field, it is also an important issue if the case is related to the organized or systematic criminality in nature. However, in the ICC, the necessity of protection of the witnesses is far more important. That is from the nature of the crime. For example, the suspect sometimes belongs to a powerful armed group which still occupies a large part of the country and exerts a power over it. Such countries or regions are in general very unsafe for the witnesses who cooperate to the ICC. Sometimes it is necessary to continue to protect the witnesses even after their testimony. Protect measures sometimes include the relocation of the witnesses and their entire family. In sum, the entire proceeding here in the ICC is very complicated and challenging. In conclusion, judges of the ICC are required to deal with such large scale of crimes throughout the proceedings to the decision of the final judgment. Additionally, the judges should have an ability to maintain stable and calm state of mind because they must face such atrocities in court in a daily basis. And finally, the work of the ICC judges is always accompanied by strong pressures and heavy responsibilities. On the other hand, there are many common issues in the ICC and the domestic field because, after all, they are criminal matters. My experiences in criminal investigation and trial procedures in Japan and my knowledge of criminal laws in general always assist me to manage the cases here in the ICC. This is my short introductory statement for today's young audience. Thank you very much for your kind attention.
Thank you so much, Judge Akane, for your captivating and interesting view on the scale and magnitude of the atrocities and the cases you are dealing with. And the protection of witnesses. I think you have delivered extraordinary issues for questions. So I think there will be a lot of questions coming in. But before that, I would like to give the floor to Judge Chung. Judge Chung will go into the Naganda case, in which the court for the first time delivered an order on reparations for such a large number of victims. Bosco Ntaganda was a deputy chief of staff and commander of operations of the Liberation Army of the Congo. He was convicted by the Eicc of war crimes and crimes against humanity in the Ituri district of the Republic of Congo. He was sentenced to 30 years of imprisonment. Judge Chung, you were the presiding judge of the reparations order in the Ntaganda case, which was delivered on the 8th of March of this year, 2021. Victims' participation and reparation are core procedures of the Eicc. Can you explain what the importance is of the reparations order in the Ntaganda case and why the development of the reparation procedure has been so delayed?
Thank you very much, Madam Ambassador. I'm also very happy to hold this Asian Pacific Forum again this year. And I'd like to appreciate all of you for joining this forum. I'm sure that all of you have overcome such a difficult period of time and also successfully changed crisis into opportunities, and why we can all here today. So I congratulate all of you for such great achievements. And I'd like to give my special thanks to Madam Ambassador, Hague Project of Peace and Justice, and also Eicc Registry for this continuous support for this event. As mentioned by Madam Ambassador, victim participation, victim reparation, these are very important and also unique process at the Eicc. Whenever we judges have new cases, we need to start victim participation process. And that's why we already have many case experience, and judges have developed many jurisprudence and practices regarding participation process. Furthermore, the judges agreed on the best practices on participation, and we put them in the Chamber's practice manual. This manual is not law yet, but once we agreed on practices, we put them in the manual first as a strong recommendation to the judges. And if that works well, then we upgraded it to the regulations as a part of law. So this is manual. So if you are interested in the victim participation process at Eicc, I recommend you to find this manual, Chamber's practice manual, in our Eicc website, and then you can find all those details of harmonized practices regarding participation process. And also the registry, especially victim participation and reparation section, VPRS, also developed their own practices and very tight protocols to support judges for this participation process. However, reparation process does not start automatically whenever we have new cases. Reparation can start only we have some conviction trial of conviction by trial chamber, and if that conviction judgment is confirmed. That's why until now, we have only 4 cases of reparations order: Lubanga, Katanga, Almaty, and most recently mentioned by Madam Ambassador, March this year, Ntaganda. Only 4 cases. That's why the development of jurisprudence and practices regarding reparation has been a little delayed than participation. And Eicc is actually the only court in the world which have something like this unique reparation system. As you may know, even in the national system, any victims can file any civil claim against the accused person. But this is a separate civil claim. But Eicc reparation is still part of a criminal procedure to allow more flexible compensation for the victims. And among UN special courts, ICTY, ICTR, SCSL, ECCC. Only ECCC has reparation process, but ECCC reparation is limited to only collective and moral reparation, while ICC doesn't have such a limitation. That's why we also, it was very limited to import some jurisprudence from the ECCC. So ICC judges had to start everything from ground zero. And this is another reason why the development of reparation has been a little delayed than participation process. But anyway, appeal chamber, using the Lubanga case and Katanga case, they have produced many meaningful jurisprudence for the reparation process. The first appeal judgment on Lubanga case, it was very much tight and strict regarding reparation process. But its second judgment regarding Katanga case, it becomes a little flexible. And the third judgment of appeal chamber, again to Lubanga case, it provides a more flexible approach for judges to reach reparations order. So based on this development and evolvement of our jurisprudence, my chamber, Untitled Chamber, could make this reparations order in a more efficient and also flexible and also precise way. But as you may know, our reparations order is still pending before appeal chamber. So according to Code of Ethics, I cannot tell the details of subject matter of our reparations order, but I will let you know how to maximize the reading of our reparations order. From the beginning, the appeal chamber emphasized 5 essential elements for reparations. So reparations order should be directly towards the accused person with some amount of liability. And this should be given to the victims according to their harm suffered, and we should provide proper type and modalities of reparations. These 5 elements requires also some principles that can be applied not only specific case, but also to future cases as well. So in the Chaganda reparations order, you can find more enhanced principles for all these 5 essential elements for reparations order. And this may help you understanding such development of international law and international standards of human rights. So I recommend you to this principal part of our reparations order. And according to these 5 elements, we also applied most up-to-date jurisprudence of the ICC. So once you read our reparations order, you can understand all necessary and proper jurisprudence of the court for all these 5 essential elements. Maybe this would be easiest way to understand and study the jurisprudence of the court regarding reparations order. And also mentioned by Madam Ambassador, this is the first case dealing with such large number of victims. So in order to accommodate such big number of victims, our chamber also developed many new practices and measures, and that are also well implemented in our reparations order. So you can find how the judges' chambers can handle such big number of victims for the purpose of reparations order as well. So I hope you enjoy reading our reparations order, and hopefully our reparations order is confirmed by appeal chamber. I believe this order could be very strong jurisprudence for the court and for the future cases. This is my answer to your first question.
Okay, thank you very much, Judge Jung. So the students are invited to follow this, and I think it's very important that you made this, jurisprudence. So for the future of international criminal law. I have a second question for you, Judge Jung. Sorry, my phone is ringing all the time. I'm very sorry. And that regards the length of trial at the ICC. It took almost 20 months for your chamber to deliver the reparations order in the Nataganda case after the conviction judgment on July 2019. if you count that the hearings in the, sorry, I'm very sorry, my phones are going, if you count that the hearings in the Nataganda case started on 2 September 2015, it means that it took your chamber almost 4 years to deliver the conviction judgment. Can you explain why it took so long, and also why the reparation order needed almost 2 years?
Thank you very much again for these very important questions. And this is really not easy answer for judges, but I'd like to give answer this way. Right, indeed, 4 years for one case is really long period of time, especially compared to national court cases, which usually takes less than 1 year. This is really a long period of time. And even worse was that in the first couple of cases at the Eicc, it took more than 4 years, sometimes 5 years, sometimes 6 years. So, and Intanganda case, my case, Intanganda case was the biggest case ever. So when we started hearing the witness testimony in September 2015, many people worried and afraid that our Intanganda case hearing may take more than 6 years. There were such many worry at the time. So our chamber did our best to make our trial proceedings more efficient and effective without damaging or prejudicing the right, especially of the accused person. We applied many new practices and also measures, and I believe these two are most important for that purpose. The first one is that we applied Rule 68, which allow judges to admit a written statement of victims, witnesses, instead of live testimony. That is Rule 68. We applied this for the first time on regular basis. Almost 1/3 of our witnesses, we applied this Rule 68. And second one is video link testimony, which allow victims to be more flexible in the availability of their testimony. Now, victims don't need to come to The Hague. They can just stay where they are and then visit the field office of Eicc in the situation country to give testimony. This also reduced huge amount of time and energy during trial. So thanks to these efforts, we could finish the whole witness testimony of 102 witnesses, and plus the closing brief of parties in 3 years. And we took almost 10 months for judgment drafting of the chambers. That's why it took 3 years and 10 months. But actually, this is the shortest ever. And considering again that this Intanganda case was the biggest case ever, I believe this is big development and improvement in terms of efficiency and effectiveness of a trial hearing. And Ongen case followed our case, Intanganda case, and it was delivered February this year. The size of these two cases are very similar. And Ongen case also applied very similar measures, practices as we did in Intanganda case. And Ongen case also took almost 4 years. Very similar size of case and very similar period of time for Ongen case as well. So my understanding is that for such size of case with 100, around 100 witnesses, I believe 4 years for hearing, so start of witness until judgment, would be minimum period of time at the Eicc due to the following two reasons. The first reason is very much a similar reason already given by Judge Akane. The one case at the Eicc is much huge and much complex than national cases. National cases, maybe at least 10 individual criminal instances at most, and also a couple of witnesses to prove that. But here, as mentioned by Judge Akane, we usually have hundreds of individual criminal behaviors. And to prove that, we usually need at least 100 witnesses. And witnesses are usually speaking other languages of our working language. Our working language is only English and French, but witnesses are usually speaking other languages. This requires interpretation, simultaneous interpretation. Sometimes we need delay interpretation from that language to French and then French to English. So we need to very much speak slowly in the courtroom. That's why we need more time than the testimony in the national court. For example, our Canada case, in average, we spent almost three hearing days for one witness. And 3 hearing days means 15 hours, because we sit 5 hours a day. So this is much longer than the time for national court witnesses, which usually take at most 2 or 3 hours for normal cases. And second one is that Rome Statute. As you may know, Rome Statute does not provide very strong detailed evidence rules. It's very big discretion is given to the judges. But one very strong principle, evidence principle, is principle of live testimony. So all the witnesses, victims, should come to the court in The Hague to give testimony in person before judges. This is the very strong principle, evidence principle in the Rome Statute. That's why we always need to invite all those victims, witnesses to the court. Now, as I mentioned, we have an exception, that is Rule 16, but exception is exception. We cannot apply this exemption more than principle. That's why we also need more time in the courtroom during the trial hearing than the trials in the national court system. So due to these reasons, I believe 4 years for one case of hundreds of instances with at least 100 witnesses would be minimum at the Eicc, from start of witness testimony till judgment, issuing judgment. If there's an amendment of Rome Statute, for example, the Rule 16 becomes principle and the principle becomes exception, then maybe I believe this period of time could be less than 3 years. But under the current Rome Statute regime, this 4 years for one case is minimum at the moment. So in the meantime, we are trying to reduce or improve efficiency of our trial hearing. We also try to make our trial hearing more transparent, so that any public can follow our trial hearing for such a long period of time. So if you go into our website, you can even watch our hearing through live streaming and also find all those submissions of parties and decisions of judges and also transcript of hearings almost real time in our website. So for such a long period of time, I hope you can enjoy such information in our website regarding our trial hearing. And reparations order, this is a little different story, because actually we can issue reparations order much faster, much earlier than 2 years. We can do it. But problem is that this reparation order becomes effective only if our judgment of conviction is confirmed by appeal chamber. But appeal chamber confirmed judgment, it usually takes around 1.5 years or 2 years sometimes. So if we issue reparations order much earlier than appeal chamber judgment, maybe this would be good news for the victims. But as we witnessed at Bemba case, if appeal chamber overturn the conviction and acquit the accused person, then this judgment and reparations order becomes nothing. And this may also, maybe we are afraid that disappoint more the victims. And that's why, even though we can issue reparations order much earlier or faster, but practice at the court now is to a little wait until by the time when the appeal chamber may issue the appeal judgment regarding the conviction. That's why it's also a little delayed than our working capacity. So this is the reality of the Eicc. Indeed, it's a long period of time, but it's necessary, according to my understanding, And I hope the public can understand it this way and enjoying all those information provided in our website during this long period of time hearing. Thank you very much.
Thank you very much, Chung, for your clear explanation. And it is clear that the reparation order is different from the general period, why it takes a long time to come to a conviction judgment. And it shows, in fact, what you both judges have explained today is the skill of the cases and the magnitude and the complexity. And so I really hope this is also clear for the listeners now. So thank you so much. And we have still time for questions. And I see questions, so let me start. I'll start from the beginning. In what condition a case might be brought to the court under Chapter 7 of the UN Charter, and how is the mechanism? Who would like to answer that?
Maybe I can give answer to this question because I was in charge of some related cases when I worked for pretrial chamber. As already mentioned in our short video, ICC is also treaty body, which means that we can exercise our jurisdiction over only to member state parties. But the only exception, official exception in the Rome Statute is referral by Security Council, as mentioned in the question, according to Chapter 7 of the UN Charter. So if the Security Council make a resolution based on Chapter 7 to refer the non-state party situation to the ICC, then we can exercise jurisdiction over such non-state parties. This is the only possibility for the ICC to exercise jurisdiction over non-state parties. So until now, we have two situations, the Sudan and Libya. And in the Sudan cases, there are many questions were raised. Even we can say that we can exercise jurisdiction, we still have many questions arising from Rome Statute regime and also from the right of the states, independent sovereign states, and also immunities issues of those people in those non-state parties. So such all questions, there were such many questions were all dealt with in my decision, which was given in the non-compliance decision in Sudan situation regarding South Africa and Jordan, South Africa and Jordan. So if you find these two decisions, you can find every answers regarding every questions arising from non-state party situation referred to by Security Council of the United Nations. So I hope if you are interested in further information regarding this non-state party situation, I recommend you to read these decisions.
Okay.
Thank you very much.
Thank you very much, Judge Chung. Yeah, I really think it's interesting. We will go to the second question. Let me see. Oh, I have. I'll take the question of Kim Boo Yoo-hong. She is studying at an Incheon National University. And my question is, how does the ICC have sovereignty to order reparation processes? And does the reparation process have genuine results in which the victims are able to receive their compensations? If victims do receive compensations, where do the reparation funds come from? Judge Chung, can you answer that question?
Yeah, maybe I need to answer again because this is my issue. So really, I did not mention that part of implementation of reparation order, but implementation is followed once we issue an reparation order. That is also important part of our court process, implementation of reparations order. And as you asked in the question, how some kind of reparation some money or some medical treatment or school training treatment, how these are given directly to the victims. This is what we call implementation. And implementation is mainly taken place by trust fund for victims, trust fund for victims. And this is another independent body at the Eicc, which are mainly dealing with this implementation of reparations. They are all experts on this reparation implementation process. And with the support of many NGOs, non-governmental organizations in the field, they really give such reparations to the victims in the field. This is the role of the trust fund for victims. But the problem is that this is also rely on the fund raised by the trust fund for victims. So not only implementation, but also fundraising is another important role of trust for victims. So for example, if judges $10 million for reparation, trust fund for victims should make some fundraising of 10 million for the victims. But this is not easy process. So I hope every one of you may be interested in the fundraising for the victims at the Eicc, for the trust fund for victims. And if you have some friends or some people who are really rich and then very much willing to make some contribution for this kind of purpose, maybe you can recommend those people to think about Eicc trust fund for victims for contribution.
Thank you very much, Chung. And I would like to echo your appeal, for the trust fund for victims. I think it is very important that they have enough funds to deal with all these cases and to compensate victims. I have a question for Judge Akane, and it's from Lucy. Judge Akane, she asked, if you're reading all those accusations of war crimes, crimes against humanity, she wonders how that affects you mentally and emotionally, and whether you have your own special coping mechanism against the heavy mental emotional toll.
Thank you very much. As I said in my statement, introductory statement, it is actually very hard for the judges to face such atrocities in daily basis. Last week, as a member of the pretrial chamber 2, we confirmed the case of the Sudan to the trial stage. As you know, there are not only the Sudan cases, but also other cases. We are acquainted to the very distressing images of the case, and also the statement of the witnesses moved deeply us. So to maintain our state of mind is very difficult. Even if I come back to my home, usually I have to continue to think about the victims and the people who are affected by the crimes. So it is not the easy solution to maintain our state of mind. But what I am doing is just think about the victims very far away from The Hague, but we are working for the victims and witnesses who are affected by the crimes. Always we are thinking what we should do and what we can do. That is what to maintain my state of calm of the state of mind. That is only my question I can answer. So it is very difficult.
It is difficult, yes, of course. I can imagine. Judge Chung, do you have anything to add?
Maybe most of the judges may experienced the similar things. But based on our previous experience as a judges or prosecutors in national systems or other international systems, we already well experienced about how to handle such difficulties. So that's why even this court is again much bigger and more serious than national court, but we can handle it. But the important one is that once you are accustomed to national system with experience as a judge, lawyer, or prosecutor in your own system, then you have some confidence in your criminal procedure or or other procedure. So you have some confidence in your own system. Then you can also switch easily to UN Eicc criminal system as well, because there are some differences, but the basics of procedure almost the same. Fact finding, legal finding, judgment based on evidence, witness. This is almost the same between national court and international court. So don't be afraid of working for international court, because the basics of the criminal procedure are almost the same. So once you are accustomed to your own system and confidence in your own system, this may help you switch easily to the international court system in the future. And also this experience also help you adjust easily once you come to this international court, even you face such more serious things at the Eicc.
Okay, thank you very much. I have a question, I think for both of you, from a Japanese public prosecutor. I'm not sure, Shushuka Kyoto. I'm not sure I say it right, so sorry. She would like to have more details about the witness protection system of the Eicc. Who would like to answer this?
Firstly, what I can answer is two things. One is court protection. In the court, inside the court system, there are two systems. One is in-court protection system. That is to use voice distortions, face distortions, and use pseudonyms to call the witnesses to protect their identified by other people outside the court. And the second one is, as I said, relocation of the victims or witnesses from the original places to the other places to protect them. But this is not the judge's work. There is a section specified to protect, to provide the Eicc's protection in the Eicc. So they are in charge of providing such kind of protection to such the people who are necessary to be protected. That is called International Criminal Court Protection System. So it is very roughly speaking, there are two types of the protection system. Maybe Judge Chun will add some other information.
I believe that that's enough for now.
Okay, thank you very much. I have another question, and it regards the skill and the using of technology. Given that cybercrimes are rising in its number, is it affecting the Eicc cases too?
Right, so we don't have such cases at the moment yet, but many academics are really seriously thinking about this cybercrime maybe constitute the jurisprudence of the Eicc. For example, if someone hacking the power plant of other country and destroy the power plant, and this may cause big number of victims because of this kind of internet hacking of this power plant. And this kind of crimes can be treated at the ICC as ICC jurisdiction. So this kind of question is already started to be discussed among academics and among NGOs, but we do not have such cases yet. But that is up to our future development of prosecution investigation. And then maybe judges need to also develop further jurisprudence or practices to accommodate those cyber crimes in the future.
Okay, thank you very much. I have another question which I lost now. Let me see. Well, I lost the question, but it was a question about how do you find after the confirmation of charges, how do you find the individual? Can one of the judges explain that process? I think
I'd like to explain about that. Confirmation of charges is the procedure after identified suspect is arrested and surrendered to the court. So already at that stage, the suspect is identified and also in the detention center of the ICC. So after the confirmation of decision, confirmation of the charges, the suspect is sent to the trial stage, and trial stage will begin.
Okay, thank you very much. I think we have still time for a few questions, and I have now one from Sri Lanka. And the question is, in Sri Lanka, in which express pearl that was carrying chemicals caught fire off the coast of Sri Lanka, leaving in its wake an environmental disaster that the island will likely to have to live with for decades. And the question is, will there be any possibility that the perpetrator will be brought before the ICC for an ecocide after it is governed under the statute? Maybe one of you judges can explain, is ecocide under the statute?
Maybe I can answer briefly. Actually, this is really important issue and already discussed a lot by many NGOs and academics. So we are as mentioned in the video, we have only crimes in our jurisdiction, but really many discussions are ongoing regarding to what extent we can expand this jurisdiction at the ICC. And one of the strong candidates is this kind of environmental crime, because the environmental crime is usually expand not just one country, but also to neighboring countries as well. So environment crime is really have some cross-border nature by itself. So this really caused many international disputes and some fights. So that's why we need some solution to solve this environmental crime as part of not only national system, but also international system. And that international system should be ICC. That's why many people are already started thinking about accommodating this environmental crime as part of ICC jurisdiction. I'm also very much interested in that. I'm waiting for some development on this issue.
Yeah, I think it's a very important one. Thank you very much, Judge Chung. I'll take one or two more questions. The first one, does the ICC still have a jurisdiction over a signatory state who later withdrew from the ICC as a state party in case a head of state committed high crimes over its citizens? This is the question from Paola. So yes, maybe I guess it is, committed high crimes over its citizens during the time they were still a signatory party, but then they withdrew. How does that work? Can one of the judges explain?
Maybe I can answer this issue because I think this is quite related to the Philippine situation at the moment, because Philippines withdrew from the Eicc, but investigators, prosecution is still investigating the Philippine situation. Then our temporal jurisdiction still can be applied to Philippines who already withdrew from the Eicc. So at the moment, we have this really pending issue before the judges. So I'm also waiting for final answer to this question from my pretrial colleagues. Maybe Judge Akane, I don't know, Judge Akane may be in charge of this case or not. So, but this is really actually pending issue before the pending and important issue before ICC judges. But the Rome Statute clearly provides that if investigation already started before the taking effect of withdrawal, then we can still exercise jurisdiction. So the one condition is that investigation should start before the taking effect of withdrawal. So if judges believe that investigation already started in Philippines regarding Philippine situation before withdrawal, then maybe yes, but otherwise no. So I'm also waiting for this answer. So I cannot tell more about this.
Okay, thank you very much. I'm afraid we have to stop here because otherwise we're running out of time. So I would like to thank Judge Akane, Judge Chung for your contribution. I think it gives a very good insight in, what you are doing at the court and how the court is functioning. I'm very sorry we couldn't answer all questions, but I thank all the students and other persons who have asked questions. And I will now give the floor back to the Master of Ceremony, Yumi. You have the floor. Thank you.
Thank you very much.
Thank you.
Thank you very much, Ambassador Strihauer. And I also thank His Excellency Judge Chun and Her Excellency Judge Akane. We now move on to the second panel discussions with a very exciting subject of the career in the field of international justice. And I have the honor to invite the moderator of the second panel, Mr. Christian Moore, Director of Divisions on External Relations of the Registry at the Eicc. Mr. Moore, the floor is yours.
Thank you very much, Yumi, and thank you to all of you taking time out to join us today. My name is Christian Marr. I'm the Director for External Operations. I'm with the Registry of the Eicc. I'd like to, and I have the honor to kick off the second segment of today, which is entitled Careers in International Justice. The focus of this session is slightly different from the first session. We've aimed for this to be a panel discussion amongst young people from the Asia Pacific who've relatively recently joined the court. And the idea is so that we can have the panelists share their experience, both in terms of getting into the court and what it's like to work for the court. So we wanted to give you a bit of a flavor what life here in the court is like, with the caveat, it's life under COVID. So everything is slightly different reality that we're working for. But before I introduce the panelists and we begin our panel discussion, I'd like to set the scene and provide a bit of background about the role that Asia Pacific states play vis-a-vis the Rome Statute. And I'd also like to talk about the overall role of Asia Pacific staff members within the court. So really to set the scene. During the panel discussion, which will follow my presentation, I'd like to make sure that, we'd like to make sure that the session is as interactive as possible. So it'll be great during my presentation if you can start thinking of the kinds of questions you'd like to pose to the panelists. Now, in doing so, the format will be the same, the Q&A segment, the box in the bottom, please enter your questions. But what I ask for you is there'll be a slight differentiation between the panel discussion and the session that Bruna, who represents our Human Resources Service, that she will be focusing on. The difference, the broad difference here is the questions for the panel. If you can primarily focus on questions that you'd like to ask the panelists about their experience and what it's like working for the court. whereas the questions for Bruna should be more along the lines of how do I get a job at the court, rules, regulations. So what she will be focusing is not necessarily the personal experience of working for the court, but very much the rules, policies, guidelines, and essentially the how-to part of working for the court. So without further ado, I'd like to kick off the presentation part of the segment before we start the panel. Can we switch kindly to the PowerPoint? Thank you. Next slide. Thank you. I'd like to start here by really talking about, first of all, the role that Asia Pacific states play in general within the context of the court, also within the context of the Rome Statute. Next slide. You heard President Hofmański mention this earlier. Essentially, we have 123 states that are states parties to the Rome Statute. The Rome Statute itself was adopted in 1998. Within record time, no one thought it was going to be that quick, but it was entered into force within 4 years. Now, if you look at the entire membership of the UN, which is 193, we have 70 more states to go to reach what we call a state of universality, which is really the end goal of the court, where every member state of the UN, every state out there is a member of the Rome Statute. Therefore, we achieve universality. The next slide, please. Just to give you an idea, this is based on the UN's categorization of different regions. Now, within the Asia Pacific region, 19 out of the 55 states that make up the Asia Pacific group are members. As President Hofmański mentioned, this is a very low number, and I'll go into that very shortly. I think there are about 2 of you, at least, joining us from Fiji today. So you have the distinction of being the first Asian member that joined in 1999. But if you look at these numbers, we've really stalled. After Vanuatu in 2011, we've had Palestine, we've had Kiribati join us, but really we've had a bit of a delay. And taking into account, those of you in the audience represent 18 members, non-state members in the Asia Pacific context. I only ask of you, and echo what was mentioned earlier, that to the extent you could help us raise these numbers by getting your states to join the Rome Statute, we would be extremely grateful. Next slide. And as I mentioned, as a proportion of the regional groupings, Asia Pacific is way below. Only 35% of the Asia Pacific states are members of the Rome Statute. This compared to Western Europe, where you have 86%. Clearly, there's a huge gap between the rest of the world. And as an Asian myself, I think this is an area we really need to get these numbers up. It's something that really requires a lot of push, not just from governments, but all of you, students, academics, civil society. This is where we need a lot of help. Next slide. I'd now like to talk about the role of staff members, Asia Pacific staff members in particular, within the ICC. Next slide. If you look at this, what the red and blue lines indicate is red being the target numbers. This is the ideal number of Asian, African, you name it, regional staff members that we want in the court. A lot of this is defined by the amount governments in that particular region contribute to the court under assessed contributions. We can go into that in more detail later on if you're interested. If you look at, for example, WEOG, Western European and others, you see that the blue actually is over the red. The ideal number in red, we should have roughly about 40% of our staff should come from Western Europe and others. But in reality, we have about 60%. If you look at Asia, it's the reverse. We should ideally have about 20%, but we have somewhere around 7% or so. And this number really hasn't moved in recent years. So this is an area where we really need a lot of push. Next slide. The most recent figures from 2021 this year, which really is a breakdown, the target for Asian staff members, we should have about 18% of the court should be staffed by Asian staff members. We have 6.26 as of the middle of this year. So what this means for those of you in the audience who are from the Asia Pacific, you are highly coveted. We really need to convince you to, first of all, apply, because to begin with, many of you do not apply, and ideally, beyond applying, to get the posts, which would really, we need to triple these numbers for us to be at parity, according to this. Next slide. There are various measures, next slide, being taken by human resources and by the court in general. A lot of this will be touched upon by Bruna. Use of social media, use of platforms like what we have right now in terms of this conference. There are various programs, but a lot of this I will ask Bruna to address in terms of efforts we are proactively taking to try to improve the disparity. Next slide. Now, amongst those of you here, I also want to flag quite a number of you represent these either non-represented or underrepresented states. This means the lower the number, the better for you, in essence. This means that in order to reach parity, nationals of your governments that are listed here need that many more staff members to be at an ideal number. The most extreme case, not just in Asia, but worldwide, is Japan. We're missing 33 Japanese staff members. So we got a long way to go in order to reach parity for Japanese. Koreans, -10. And you see Bangladesh, I think we have no Bangladeshis. And I've worked for many international organizations, but this is the first time I've had no Bangladeshi colleagues. I can assure you there's a very good supermarket in The Hague that sells very good Bengali food. So please, that shouldn't be a hindrance for you to consider a job opportunity here in The Hague. Can we go to the next slide, please? If you could go to the next slide, please. Just to really focus on the fact that, yes, there are a lot of lawyers at the ICC. I'm a lawyer. Many of us in this room are lawyers. However, lawyers are not the only people we are looking for. If you look at this chart, it might be a little small on your screen, but we're looking for a variety of different tasks. Of course, lawyers make up the biggest number. We have over 200 lawyers, but likewise, we need experts in administration, in finance, in IT, in security, in terms of external relations. Many of these people in the categories that doesn't say legal are lawyers as well, but it doesn't mean that if you're not a lawyer, we're not looking for you. So if you're an IT expert, please, this is something that shouldn't keep you from considering a career in the court. Next slide. Above and beyond the geographical representation, I would be remiss if I also didn't call attention to the fact that we are clearly in need of more women to work for the court. If you look at the bottom right-hand corner, as a general percentage, we're not doing too bad in terms of male-female representation. But if you look, D1 is the highest level, all the way down to P1 amongst the professional grade. You see a very clear pyramid where we have very few women at the top and more women at the bottom. This is something that we are also trying to change so that we ideally have parity, so that we have an equal representation of both men and women at the highest grades as well. So this is indeed a work in progress. All this to say, if you're Asian and you're a woman, this is as good as it gets. Not to say I discourage any men, but in general, that's just makes it that much more yourselves attractive as a candidate to the court. The next slide, please. Thank you. So now that was my overview. I'd now like to go to the next phase, which is to introduce the panelists. Can we go to the next slide, please? I'd like to briefly just mention their names because I'll be asking each of them to introduce themselves. But we have from our registry, Kyung-Sun Kim. We have Young-Sun Kim, who's with the Office of the Prosecutor, and we have David Mansfield, who's with Chambers. So without further ado, if we could switch to the panelists, and I'd like to kick off the panel session. And Bruna, whom I have yet to introduce, will be here for largely the second segment. She is our representative from Human Resources and will be able to answer a lot of the detailed questions as to, once again, how do you work for the court? Very good. So I'd like to pose the very first question. Once again, we are clearly now open to any questions that you'd like to pose to the panelists, but I'd like to use the pretext of myself being the moderator to kick off with the very first question. The first question being, if you could give us a bit of your background, your role, what do you do within the court? And if you can give us briefly how you came about, what sort of path did you follow to come and work for the court? I'll give each of you about 3-4 minutes so that we could give all our participants a bit of a flavor as to what sort of led you and how you find yourself in the court. So perhaps I'll start with David, who is right to my right, at least on my screen. David Mansfield, you have the floor. Thank you.
Thank you very much, Christian. My name is David Mansfield, and I work at the trial division of the Eicc as a legal officer, and I provide legal support to the judges, primarily those who belong to the trial division. And I have been with the court for about 2 years now, and I was originally here as an intern. So I would like to really stress today that it's always a good place to start by applying to an internship rather than aiming for a higher position. And I also have an academic background. I used to do my PhD at the University of Tokyo before coming here. And yes, I think as Christian mentioned, however, the Eicc is not only for lawyers. So I think in that sense, we have a very diverse and good panel today. We'll be able to answer questions from different angles, I hope. And I think that's it for my side.
Thank you very much, David. Then I'll go to you, Hyung-sun Kim, please.
Hello. Hi, everyone. It's nice meeting you, everybody. My name is Hyun-sun Kim. I joined the court fairly recently, January this year, and I work at the registry. The registry is the management and administrative organ of the court. We are the group of 600 plus staff members, and we give support to the various functions at the court. And my office is where the group of advisors to the registrar that we are located there, and we provide policy reviews, strategic advices to the registrar as a head of the registry to help his decision making. And my main duty there is to support the registrar's strategic planning. I draft midterm and long-term strategic plans. I develop tools and indicators to measure the performance. And once we have the result, I draft the progress report to share with the member states so that they are well informed of our organizational performance. And to briefly share with you how I ended up here. I studied my bachelor in law in Korea. I had an internship when I was a student at a Korean human rights NGO that support the rights of the Rohingya minorities. And I got to know more about the concept of international human rights, and I got fascinated by the idea. And actually, after I graduated, I joined the government agency where I can go directly to the developing countries by providing assistance projects. And there, because of my background in law, I did a lot of projects in relations to rule of law, forced migration, protection of children and women, which naturally gave me this new idea of international criminal justice. And I just wanted to gain more specialized experience in the field. So I started my master's in the Netherlands, master's in public international law, and I applied for the position called Junior Professional Officer Program. It's a program which you'll hear more about in the later session. It's a program supported by the Korean government. And yeah, here I am. Thank you.
Thank you very much, Young-sun. I'd now like to give you the floor, Young-sun.
Thank you. Hello, everyone. My name is Yang-sun, and I'm also from South Korea. And I'm currently an intern at the Office of the Prosecutor at the Eicc. So to briefly introduce myself, I studied political science and international studies for my undergraduate. Then I completed the Holocaust and Genocide Studies as my master program in the Netherlands. Before coming to the court, I did several years of volunteer and internships at NGOs in the field of human rights, transitional justice, and conflict-related sexual violence. Especially from the previous internship at an NGO, I got to meet survivors of sexual violence during conflicts in 20 countries. There, I got to learn about how important it is for survivors to have justice. And these experiences have motivated me to become interested in fighting against impunity for crimes against humanity, war crimes, and genocide through emphasis on the participation of victims, which is the missions of the International Criminal Court. So motivated and inspired by the Eicc missions, I've decided to apply for the internship here. And I ended up applying for 9. And luckily, I got one of them. And I started working here since last November. And regarding my role within the court, I am in the investigative analysis section at the Office of the Prosecutor, and I am assigned to a specific country case. Here, I've assisted and closely worked with investigators, analysts, and lawyers in the team, and I've got to learn about how each role plays within the OTP. And I've used several database tools to process, analyze, and research different types of evidence, such as witness statements, imagery, and social media accounts. And also I have undertaken tasks including conducting reviews and checks on evidence, or working on projects such as creating a timeline and doing crime-based research. As you can tell from my story, I don't have any legal background. Thus, I would like to emphasize that the Eicc internship is not only for those who have legal degrees, but also for non-law graduates interested in crime analysis, intelligence, open source, or international security. Thank you.
Thank you very much, Young-sun. I'd now like to go to the second question. In a way, it's a broad question, but I'll very much leave it up to each of you to, based on the experience you've had in the court, to talk about it. Really, I'd like to hear from you 2 aspects. One is, what do you enjoy most about working for the court? But on the other hand, what are some of the bigger challenges you've encountered as a result of working for the court? I'll mix up the order a little bit so we keep you on your toes. Young-sun, could you take the floor first? Kyung-sun,
Hyun-sun or Yang-sun? Hyun-sun? Okay, yeah,
sorry,
I was confused.
Young-sun.
Okay, right. Okay, I'll give it a go. I can definitely, the part that I enjoy the most is the feeling of serving the mandate of fighting against impunity. That goes without saying. I think many of my colleagues here can also relate, but I can elaborate maybe more on the part that I enjoy by working at the registry. As I open registry is a management organ where you can have a very good bird eye view of how the court actually works, and then what the players are there at play to give a support to the court functioning. And the more I understand about this concept of administration of justice, especially the administration of international justice, the more I found it very fascinating, because there are many sets of different players at play, diverse stakeholders advancing their opinions, and then we constantly make delicate decision. For me, it looks like a very well rehearsed, very well practice orchestra where all sets of different staff members and experts come here to set the scene, and then the feeling of being part of the scene is very enjoyable. And the challenges I found obviously is also many of my other colleagues can relate, is that sometimes I come across, at the court, when you hear the judgment, you come across with a very raw description of this atrocity. I mean, I don't come across many as the other colleagues who work in the courtroom, but still, when you get to hear more about the story, it's really hard to keep your head cool, but you should really keep your heart warm. But it's really hard to find a balance. Sometimes I found it very emotional. But that also give me a sense of motivation that I really need to do a better job here. But it's not a challenge per se, but it's some element that you really need to cope with by working at the international court.
Thank you very much. This time I will ask Yang Sun. Yeah.
Thank you. So one of the what I enjoy most about working at the court, meeting people, even though sometimes it is through virtual settings because of the current situation. So I got to talk with a lot of people who are the behind the scene of all the hearings, and especially like in terms of the OTP, I want to say it was eye-opening experience for me because I got to talk to investigators and analysts and forensic experts. So before coming to the court, I thought there was only one single career path that I can do. But now I know that there are a lot of career paths, and then I got career advice from all of the people. And then I really enjoy how everyone ended up coming here. And one of the challenges that I face is, I will talk about it in terms of an intern. I found it really hard to establish my work identity in the beginning of my internship. And then I discussed it with my supervisor, and my supervisor advised me like to identify my weakness and the strengths of my work ability. And then I did that, and then I reflected on my daily works, and then get some feedbacks from my supervisor and then colleagues. And then that made me able to adapt to this working here. And so it was one of the challenges, but it was really great. It was really grateful for this challenge because it made me grow. Thank you.
Thank you very much. David.
Thank you. And I think Hansen kicked off this round of answers very nicely by saying that it's a sensation of serving a very high purpose, with which I fully agree. But to give a more answer that's specific to the judiciary, I would say that it's the ability to work with the judges, and the judges being, of course, one of the leading individuals in the field of international criminal justice. Of course, my job is to provide legal assistance to the judges, but quite often it's me who's getting a lot of experience, especially having an academic background, and it's really a learning experience for me. And I have nothing but deepest respect for all the judges I've worked with. So it's really that feeling that's really important for me, especially as a junior individual working in this field. Challenges, I think I need to give a more multi-layered answer. Of course, one of the main challenges for me is languages, and I'm not a native English speaker. French also being an official language of the court, that also poses additional difficulty for me. But also, I think as I think Hansen or Yang-sun mentioned, it is of course difficult when you have to work with crimes, alleged crimes that's of such gravity. And I think this was also mentioned by the judges in the first session, by Judge Khan and Judge Chon. But especially when we see testimony from alleged victims who appear in court, those who have suffered from alleged sexual or gender-based crimes, and quite often those alleged victims are much younger than myself, and that's really difficult for me. And it nonetheless is a moment where I get reassured that we are indeed, as Hansen mentioned, working for the broader project of international justice, which matters a lot. Thanks.
Thank you very much, all three of you. I'd now like to start taking questions that we have from the floor. Given that we have a number of them, I was thinking of posing it and letting you either raise your hand if you feel you're most appropriate for it, or I might just ask one of you, depending on the type of question that's come. So first of all, I think I'll just go ahead and answer the first one. I think there was a question whether we are all based in The Hague. Yes, we are. We're all working virtually. A lot of it depends on the COVID situation, but we're eagerly awaiting the possibility of going back and working. But we are not quite there yet, that everyone is back in the building. A number of people have returned. Let me go to the first question, which is really, we have a question from a student who's earned an MA in conflict resolution related to international political science. I'm interested in pursuing a career at the Eicc. What kind of courses would you recommend me to take? I was thinking, well, I know David, you've just also been associated with university. Yang Sun, I think you're also very close to school. So perhaps either one of you, I don't want to keep you Hyung Sun either, but David, go ahead.
Yeah, of course. I mean, I actually get this question quite often since I've started working at the Eicc, and my answer is always that you should never choose your course based on whether it contributes to your possibility of being an Eicc staff member. And my advice is always to do whatever that's most interesting for you, because becoming a staff member is a lot of variables. And when you do a master's, it should be something that you're truly engaged in. And that being said, Christian, I think this was mentioned by Judge Chung in the first session that the thing about international criminal law is that there's a lot of similarities in terms of procedural matters. And I'm speaking, of course, in terms of more legal positions. There's a lot of similarities with the national system. And quite often, I think when people imagine that we work for the court, there's like, they focus more on the dynamic things about how we interpret the crimes, but that's actually a very small part of what we do at the judiciary. And our focus is more on day-to-day criminal law matters. So I think in that sense, and I mentioned this specifically for those who are interested in the legal positions, I think it'll be good if you have knowledge of criminal law matters, not necessarily about international criminal law. It can be about your country's criminal law as well. And I think Hansen or Yang-sun can give a more answer for the more broader audience, maybe.
Thank you, David. Either one, Yang-sun, Hyung-sun, would you like to take the floor?
I can briefly talk about the OTP perspective. So if it really depends on the position that you're thinking of. So for example, for my section, it's really important to have a background or knowledge of how to use databases to analyze or process documents into certain database tools. It's not necessary and it's not required, but if you have a knowledge of open source investigation or how to do investigation or crime analysis or other things, that would be a really benefit. So that's my advice. And then there's another thing that I want to talk about. So before coming here, I attended several conferences and workshops related to the Eicc, and it helped me really a lot to gain knowledge about it. So outside of the school, there will be more chances that you can familiarize yourself with the Eicc. So I recommend to do that as well. Thank you.
Thank you very much. Are you okay, Hyung-sun? No,
no. I think my two colleagues will compliment me here. Maybe just to add one more. As Christian, you opened in the beginning that the degree in law is absolutely is a plus, but it's not necessary. And then there are several different skill sets that you can bring to the court. And then if you are interested in working at the court, maybe you can take a look at what the skill sets that you can bring in terms of serving a specific position. And at the registry, of course, like judiciary and OTP, we have the defense support, we have victim support, victims participation, victims protection. So there are several other positions that you can delve into. So maybe you can take maybe short course rather than completing the whole master, like second master. You can go to Hague International Academy that we have on an annual basis. Is very informative, and there are other online courses that you can learn more about criminal law.
Thank you very much, Hyung-sun. I have a question specifically to Yang-sun regarding the internship. The first question, part of it is whether it's remunerated. I can answer that it's not, unfortunately, but there are certain circumstances or certain nationalities where that applies. I'll ask Bruna to take that on later on. But if you could answer the second part of this question, which is, how do Eicc interns from Asia far from home, how do you cope with what's it like living in Den Haag, living as an intern far away from home? Over to you.
So I guess I can talk about two parts. So when I first came, I had to start working remotely. However, my co-interns and my supervisor organized virtual drinks and virtual after work event. So that's how I got to know my colleagues through that. But as the lockdown measure got lifted, I got to meet some of my co-interns, and it's my personal experience, but I really enjoyed it a lot. Like, it's not relevant to the Eicc, but I really enjoy cycling in the Hague. And then the Hague itself is really international city. So you will get to meet other interns who are working in on other international organizations, which will be really great opportunity to network. Also, the Hague is next to the beach. So when the weather allows us to have a sunny weather, we can go to the beach and then we can enjoy the sun as well. And then it's really eye-opening experience. So I really recommend people to try. I know it's scary, like coming all the way from Asia, but it's really, really worth it. So I really recommend it.
Thank you very much, Young-sun. Actually, there's another question focused to you and David as well as former interns. There's a question which says, if you could go back in time and send a message to yourself when you were an intern or before you were an intern, what would you go back and tell yourself based on the experience you've had as an intern or you're having as an intern here at the Eicc? Perhaps, David, do you want to give that a shot?
I'm not sure if I fully understood your question, but sorry, did you ask what I would have done differently, or?
If you could go back in time and send a message to yourself when you were an intern or before you were an intern, what would you tell yourself? And I assume it would be either perhaps experience you might have wanted to have had before you applied for it, or preparations you might have. That's how I interpret it. But please feel free to interpret it with your own.
Oh, of course, thank you. Yeah, I mean, if I could tell myself while I was an intern, I would tell him that no worries, you'll get paid in 6 months. But of course, I think I'll focus more on what I would have done more when I was a university student or before applying for an intern or while an intern. That's definitely language. If you want to work here, it's essential that you have a certain level of English, but it's also very important that you have a basic understanding of French. And for me, I should have done more in French, especially because I have a academic background in international law. I should have done more French when I was doing my undergraduate studies. The other thing is, well, I regret not studying a lot about Japanese criminal law or criminal procedure, because as I might have mentioned, my background is in public international law, and I hadn't focused much on Japanese domestic criminal law. And I'm actually paying for that at the moment. Since I've become a staff member, I read more books actually on Japanese criminal and criminal procedure. So I think that's one of the things I would have done more. Yeah.
Thank you. Young-sun?
I totally agree with David. I think the language skill is very critical, but so if I have opportunity to talk to past me, I would say learn French, but I want to make sure that there is a chance that you can learn French here within the court as well. There are some courses offered by the Eicc. So I didn't know any French at all before coming here, but the Eicc Council offers some French courses. So I got to know about it. So I know, like, and then another thing that I want to make sure is the uniqueness. I found that if you have unique experience, you will have more opportunities to add the values to the Eicc. So I think having more, having a uniqueness is very great as well.
Thank you very much, Young-sun. It was, I think, time has just flown right by. I think we're left with one last question. What I'd like to ask you is, within the next 2-3 minutes, can you give us for an advice for people who aspire to work for the court based on your experience? Can you, one thing, if you were to give someone advice, what would it be? Could I start with you, Hyung-sun?
Thank you. Well, I'm not sure if I'm in the position to give advice per se, but if based on my experience, I would encourage people plan in the long term. I mean, work at Eicc is a fascinating idea, but it's true that it might not come around easy as it can be. So if you have maybe a bigger horizon, it doesn't have to be your first job. Apparently, there are many different jobs that require at least minimum 2 years of experience, and most of the job requires 5 years plus. But that, precluding the internship and visiting professional positions. But if you have this vision and the sense of the duty that you want to eventually work at the core, you can build your skill set, you can have a different experience, including those in the field. If I add a little more, my field experience in Africa was definitely a big plus. That's the feedback that I got during the recruitment process, because I could immediately visualize the impact in the field. I can associate the victims in the field. So, and then you have international multicultural experience that you can back up. So if you have different sets of experiences and academic skills and professional skill, of course, it will come around eventually. Might not be straight away, but getting experience in the domestic jurisdiction is, and in your specialized area, I would really want to recommend that too. Yeah.
Thank you very much, Hyun-sun. I'll give the floor to you, David.
Sure, and my advice is that you should apply. And as you mentioned, Christian, of course, the Asia Pacific region is grossly underrepresented, but that's because people aren't applying. And of course, well, it's difficult for us because, we have to travel for a longer distance. There's more of an emotional distance as well for us. But, well, applying doesn't cost you anything. So I would really encourage everyone to apply. At the moment, there's an opening for a Korean JPO at the chambers. There's also an PT roster for the judiciary. So I would really encourage everyone to just apply. And also another thing I'd recommend is to really consider doing an internship. And I know it's hard to do an internship for 6 months without being paid, but there are tools that you can use. For example, I think the Japanese Minister of Foreign Affairs has started a program which provides very generous funding for interns working at international judicial organizations, including the Eicc. I think it started a couple of years ago, maybe last year. And it's important because an internship is an opportunity for you to understand and know what you can expect from being a staff member at the Eicc. It's also important because your future supervisors get to know how you work. And that's, in my personal view, definitely an advantage when you apply for a formal staff member's position. So again, my advice is to apply for a position and also consider internships. Thanks.
Thank you, David. Absolutely on point on that. Thank you. Young-sun, you have the floor.
I'm going to echo what David said. So I have advice for people who are considering to apply for internships at the Eicc. So somebody told me a story of an apple. So imagine there are a lot of people talking about apple, how it tastes like, how it looks like, but you never know how it tastes like and how it looks like until you grab it and taste it, right? So I think eating an apple is similar to working at the Eicc. So I never imagined myself. So I attended several conferences, I read numerous articles, but I never got to know what the true Eicc really is until I came here and worked with the people. So I'm really grateful for PESME for applying to 9 internships and for accepting any challenge here and for growing here. And then I have so many questions about the Eicc, and then my answers got answered. My questions got answered, and then I have so many questions that I'm going to explore after the internship. And I'm pretty sure everyone's questions and answers that they will get here will be different and unique. So my advice is please apply and experience your own Eicc.
Thank you. That's wonderful, Young-sun. Thank you. And I'm really glad as the host that you use the analogy of an apple and not a lemon. So I appreciate that. Thank you. Thank you, all 3 of you panelists, David, Hyun-sun, Young-sun. You've been wonderful. Yumi, I know I'm a few minutes over time. I will give you the floor right back. So thank you again to all the panelists. Bye-bye.
Thank you very much, Mr. Mar, and all the panelists. We continue on this topic of jobs and internships at the Eicc. And as Mr. Mar briefly presented, the representative of Human Resources section, Ms. Bruna Hofmann, is with us today. And I would like to invite Bruna to give a presentation on how to apply for the Eicc positions. Bruna, please, you have the floor.
Thank you, Yumi. Thank you all. It's a pleasure to be here with you. And I believe my colleagues already gave a lot of important insights. And so I'll just give some general and more practical tips on how you can work at the Eicc. And I think we have a lot of questions. I'm seeing the Q&A box. There are a lot of questions about the internship opportunities and JPO, and I'm happy to reply in the end, but I believe my presentation will already cover some of these questions. So as Yumi said, my name is Bruna Hofmański. I work at the Human Resources section of the Eicc, and my team is responsible for the internship visiting professional program, but also the junior professional officer program. And during my presentation, I'll cover also staff positions and career opportunities in general at the Eicc. So if I could have the presentation now. Yeah, perfect. Yes, we can move to the next slide. Yes, as my colleagues already mentioned, we are looking for lawyers, but also non-lawyers. And I must say that we receive a lot of applications from lawyers, and sometimes this is not what we are looking for. So always try to look what are the requirements. I'm gonna explain this a bit later. But the biggest employer at the court is the registry, so where Yunsan works. And that's why we have so many positions also in non-legal fields. You can skip to the next slide, please. Yes. And also, as it was already mentioned by others, the geographical representation is very important at the court. Applicants from all nationalities can apply and have a job at the court, but we give preference to nationals of non-represented and underrepresented state parties. So here in this slide, I mentioned a few of the big underrepresented and non-represented countries. So if you have one of these nationalities or the other nationalities mentioned by Mr. Marr, I really encourage you to apply because you have a lot of chances of getting a position at the court. You can move to the next slide. As Mr. Marr also mentioned, we are taking a lot of initiatives to change the underrepresentation of the Asia Pacific region at the Eicc. And one of these initiatives is through social media. We're trying to attract more applicants. So in case you don't have LinkedIn account, I encourage you to create a LinkedIn profile, to follow the Eicc page, and to like and share our content. This also will allow you to stay connected with the court and see any new vacancies that are advertised on the website and social media. Next slide, please. So all our staff positions are advertised on the Eicc website. And if we go to our website now, we would see these positions, for example. And you see that there are different levels. And next slide, please. And a lot of people ask me, what education and work experience do I need for a position at the Eicc? So this really varies according to the position you're applying. But you don't need to worry because everything will be already described in the job description in the vacancy announcement. So here I included an example of a job description. And in all job descriptions, you will find essential qualifications. So there you will find the education you need, the experience, the skills, and also the language. And we do have two languages at the court, two working languages, English and French. And for most positions, you need to have to be proficient in one of them. If you're proficient in both of them, this is an asset, but you only need to be usually in one of them. Next slide, please. Yes, another initiative is the internship and visiting professional and JPO programs. As you've seen with other panel members, these programs are important entry points to the Eicc. I was an intern myself, and I got a position later. So you can see that usually when you're an intern or visiting professional, you're very competitive for a staff position in the future. I will explain the difference between these programs and the requirements. But just for you to know, the internship and visiting professional is a big program that we have at the court. We have more than 200 participants every year. So next slide, please. So what are the difference between an intern and a visiting professional? A lot of people also ask me that. So internships are focused on professionals in the beginning of their professional careers. So you need to have less than 3 years of relevant work experience. And this work experience needs to be relevant. It cannot be anything that you did in the past. So it needs to be relevant to the work you'll be performing at the court. You also need to be in the last years of your bachelor's degree or further in your academic path. You need to speak English or French, and you need to be available for a full-time internship that lasts the minimum of 3 months and maximum of 6 months. Visiting professionals are a bit different. We are focusing more on professionals already with some background. So you need to have at least 3 years of relevant work experience to be a visiting professional. We do receive many scholars, professors, and judges from national jurisdictions as visiting professionals at the court. The language requirement is the same. You need to speak English or French, and you must be available for a full-time placement that lasts from 1 to 6 months. Next slide, please. So another thing that many people ask is, when are the internships and visiting professionals advertised? And this is throughout the year. So that's why we recommend that you follow us on social media, so you receive a notification every time there is a new position. But I can tell you that every other week we have new positions being advertised. So we recruit interns and visiting professionals throughout the year. And we have interns and visiting professionals starting every month. All the positions are on their website. As I mentioned, this is what our website looks like. And we don't receive applications via email or post. So please, you need to go through our e-recruitment website, create an account, create a profile, and then you can apply to as many positions as you're interested in. Next slide, please. So as it was already mentioned, unfortunately, most of the positions of internships and visiting professionals are unfunded. So applicants need to find some source of funding with their governments or universities. But we do have a limited amount of funded positions at the court. This is, for example, the visiting professionals funded by the European Commission grant. This is advertised usually in August every year. This year, due to some delays in the negotiation of the grant, we won't have this opportunity available, but we hope to have it next year again. But we also have positions funded by the Trust Fund for interns and visiting professionals from developing regions. This trust fund receives donations from state parties and staff members, and the funding is allocated to some participants coming from developing countries that are state parties. In any case, when a position is funded, you're going to see in the job description that it will be mentioned as funded. So there won't be any doubt. So the funding is not provided when a position is advertised without this disclaimer. Next slide, please. So I believe my other colleagues already mentioned the experience working as an intern and visiting professional is really rewarding. You have the opportunity to work in a multicultural environment with people from many different countries. You also learn how the court works, how the international criminal justice system works, and you have the opportunity to live in The Hague, which is a beautiful city, very international and full of culture. Next slide. The other entry point that we could mention that is worth mentioning is the Junior Professional Officer, or JPO program. So JPO program is almost the same as what we have in the UN and is based on bilateral agreements between the Eicc and donor countries. Currently, we have 6 donor countries, so Japan, Korea, Switzerland, Germany, France, and Finland. So JPOs are recruited as staff members at the P2 level, so they are fully funded as any staff members. They need to have a minimum of 2 years of professional experience if they have a master's degree, but if you have just a first level degree, you need 4 years of professional experience. GPOs cannot be older than 32 years of age when applying, and they are nationals from these countries, from the participating countries. As David mentioned, we have a new GPO position advertised in our website. So it's Associate Legal Officer in Chambers to work with the judges. The deadline to apply is 6 August. So in case you have the profile, you're South Korean, you study law, and you are interested in working in Chambers, I recommend that you apply because it's a wonderful opportunity. Next slide, please. Yeah, so I believe this was the overview I had for you this morning in The Hague, afternoon and evening where you are. And this is our email address for the internship and GPO. But if you have questions about applying for staff positions, you can also send us and my team will be happy to reply. But I see that there are many questions in the Q&A, so I'll maybe jump to that. Is that okay, Yumi?
Yes, of course, Verena.
Okay, I saw a question to Hyun-sun, and it was about the GPO. Once you apply for a GPO position, which I believe is the case, this person applied now, what are the steps that are expected to happen in the future? So once you apply for a position, what happens is when the position closes, the hiring managers have a look at all the applicants. It's not the HR, it's the hiring manager who's gonna have a look, and then they're gonna select a short list of candidates. And once they select this and we confirm that the candidates are eligible according to the years of experience and the requirements of the vacancy announcement, we make sure to invite this person for a written test. And those who are successful in the written test are invited for an interview. And then we select the successful candidate, and usually the person can start after all the appointment procedures. Let me see other questions here. I see a question, what are the reasons for that the Asia Pacific representation is low? Many of my colleagues have already mentioned, we don't receive a lot of applications from Asia Pacific. We are looking for people, and sometimes we use LinkedIn to try to source candidates from this region, but it's difficult. So we are trying all we can to make sure that these positions are visible and are made aware to candidates, so we are able to have more applicants. So this is the main reason why. There is also some people mentioned that the vacancy announcements at the court can sometimes be very scary because we include a lot of requirements, but I would like to make sure to tell you that in case you have skill or a training that is really necessary, this is gonna be mentioned as mandatory, but usually what we mention is just like if you have French is an asset, so it's not required. If you don't have French, you're still invited to apply for a position. So in case you feel most of the requirements of the vacancy announcement, I would encourage you to apply for the position. Okay, thank you. I would like to ask if it's possible for individuals to apply for position if they are nationals of countries in the Asia Pacific that have not ratified. I mentioned this during the presentation. The positions at the court are open to non-state parties as well. But of course, we give priority to candidates from state parties and under and non-represented countries. But as Mr. Mar mentioned, we are looking for universality. So we are open to applications from all nationalities. Another question. Yes, someone is asking, the person has experience in moot court competitions, but that would that be enough to make me a considerable candidate for an internship? So for internships, you don't need to have any professional experience. We are really focusing on people in the beginning of their careers. So yes, you're eligible for an internship, and I would invite you to apply. Okay. Another question about the experience. So as I mentioned, for internships, you should not focus so much on the experience. You should focus on the requirements regarding education. So in case you apply for an internship, let's say with the Office of the Prosecutor investigation, they are going to ask for a profile or studies based on analysis, data analysis, let's say, or international relations like Youngsun. So these are the kind of requirements you should focus because experience is not needed. Okay, now let me see what other questions. Yeah, what kind of experience should Japanese lawyers have prior to working at this ICC? So this really depends on the position you're applying to. I could mention, for example, there is an associate legal officer position in Chambers open. And for that position, you need to have a diploma in international criminal law or related fields. So we are also quite open about the studies that we require, but this will be mentioned in the vacancy announcement in the job descriptions. I would also like to mention that for now, as Mr. Marr and other participants mentioned, because of COVID, we are working from home. So interns and visiting professionals are still mainly working from home, but we are hoping to get back to the building very soon. And but internships and visiting professionals are still from The Hague. So even if you're working from home, you usually need to be in The Hague to start a position. Let me see, there are many other questions. Is there an age limit for internship? There is no age limit for an internship as long as you don't have more than 3 years of relevant work experience. So it's the relevant work experience that is relevant in this case. What is important experience for non-legal positions? It really depends. So for an internship in human resources, we would require that you have some studies or at least interest in human resources matter. But of course, if you're applying for an internship in finance, you need a different background. So it really depends on the position. Since the internship is not paid, is it possible to do part-time jobs alongside to fund ourselves? So unfortunately, this is not possible. For European candidates, this is possible because they are allowed to work in the Schengen area. But for non-European, unfortunately, this is not possible. So that's why we encourage students to get some kind of grant or a scholarship so they are able to fund themselves during the duration of their internships. What kind of written test would it be for JPO position? So I could mention, for example, Yoonsun, she applied for a JPO position with the immediate office of the registrar. And the written test was focused on the matters that are relevant to the strategic plan. So they asked her to reply a number of questions of how she would implement some points of the plan from the registry. But in case you're applying for an investigator or associate investigator JPO position, there will be a different type of written test. So this varies a lot, but I must say that mainly it's open questions that you're asked to provide your knowledge about the court and about the work of that particular office. What kind of funding support are there apart from on government? So we know that some universities also provide some kind of funding, and not only universities, but also associations. So you should have a look at those. And as David mentioned, we know that government of Japan usually provide this kind of funding to their nationals working for international organizations. So I would recommend that you have a look on their website. How long does it take to be on board from application? So this is a tricky question because some of the positions, for example, internships in chambers, they are open throughout the year. So you're going to see that the deadline is the end of the year. But in case a chamber or a judge needs an intern, they could recruit the person throughout the year. So it's always good that you mention what is your earliest and latest availability. We ask you that when you're applying, and then we try to arrange so that the internship will fit your availability. Okay, I have domestic legal experience in private law. Would it be a disadvantage? No, I don't think it's a disadvantage. Actually, all the experience you get in your national system is very useful when you're doing an internship. So I don't think this would hurt you or this would compromise your application. Actually, many people ask, should I do an international criminal law degree? And I always mention that we do have a lot of applicants from Leiden University, International Criminal Law. So if you have this profile, you're gonna be in the same level as many other applicants that apply for positions at the Eicc. It's always good to be different. So when we see a degree from another university, an university in Asia, this calls our attention. So it's really important for you to try to differentiate. And I think Yang Sung has already mentioned, you need to be special. So if you're a lawyer, but also interested about finance or other things, we would encourage you to really focus on that, because it's much better for us to have a lawyer that knows how to function like the financial part of the court, or how data analysis is managed, than someone who only has a legal background. So this is always an advantage for you to have. Also regarding language, sometimes we need people with different languages, and this is always an asset. Okay, is there any other requirement other than the general requirement listed on the JPO, on the job post for internships, such as written tests for JPOs? So for internships and visiting professionals, we have different steps for the recruitment process. So when you apply for an internship, sometimes you can get a call from the hiring manager or the HR just to assess some of the things that are not clear in your profile, and also to determine if you're a good fit, but there are no written tests or interviews. Okay. Yes, one of the questions here is, in the UN and some other organizations, when you do an internship, you need to wait a period of time before applying for a staff position. At the Eicc, we don't have this rule, which is very good for us. So when you're doing your internship, in case you see a position that interests you, you can already apply while you're doing your internship. And if you're selected, you can start immediately. So this is quite different from the UN. Okay, another question about visiting professional. A person who has more than 3 years of experience. Are the criteria of visiting professional different from the ones of interns? Yes. So for internships, you cannot have more than 3 years of relevant work experience. And for visiting professionals, you need to have more than 3 years. So that's the requirement. And also regarding the education. So for a visiting professional, you need to have completed a first level degree, while for an internship, you can be in the final stages of your first level university degree. There's a new question coming about the JPO program. Can you tell more about the specific, how to apply for a JPO? So applying for a JPO is very similar to applying for a normal staff position. So if you go to our website, you need to create an account and then create a profile. And then you have to write a motivation letter, submit a document with your experience, and you can apply right away. Once this is done, the process is a bit different. As I said, there are written tests, there are interviews, and then it's also the selected candidates are approved by the country and by the Eicc, so they need double approval. But other than that, the recruitment is the same. And I think I have completed all the questions. There is still one. Is the ICC staff working remotely like the UN? Yes, so most of the ICC staff is still working remotely, but we are slowly going back to the building again. For internship eligibility, the final stages of university degree means that you need to be in the final year. Yes, it means the final year of your bachelor's degree or further. You can have already completed first level degree or a master's degree, but you cannot have more than 3 years of relevant work experience. I think that's it. Okay, I hope I replied to all the questions. And in case you have any questions, you have our email address and my team will be happy to help you and to reply to any other questions that you may have after this presentation. After having all this information, you might have some further questions, but don't worry, you just contact us and we'll be happy to reply to you. So thank you very much, Yumi.
No, thank you so much, Bruna. It was very informative and practical. I'm sure many of the participants found it very helpful, and thanks for addressing all the questions. Now I'm looking at the clock. We came to an end of this forum. So I would like to sincerely thank all the speakers today, the President, Ambassador van der Nijssel, Ambassador Stihauer, Judge Chun, Judge Akane, Mr. Christian Marr, Hyun-sun, David, Janssen, and Bruna. And most importantly, thank you so much for those who participated in this forum, mostly from the Asia Pacific region. I truly appreciate your active participation today. And also we are very grateful for the interest and support in general for the International Criminal Court. As Bruna mentioned, please follow us on LinkedIn if you haven't done so yet. With that note, I would like to call this meeting adjourned, and I wish you all a very nice weekend. Thank you very much, and goodbye.